computer.
And I'm going to share my screen, by the way. It's not going to be Ben this time.
Yeah,
Oh, okay.
Ed's doing the scrolling.
I'll get everybody in. Okay. Okay, good morning, everybody, and welcome to the first, what I would call Lunch and Learn legal series of 2021. And I want to thank everybody for coming in today. And hopefully you will at least walk away today with some knowledge you didn't have, or reinforce some thinking about what to look forward to and what are the pitfalls for 2021 coming up in the healthcare industry. So with that, I'm going to turn it over to my friend and colleague for the first time this year, and that's Ben. Ben, go ahead.
Thank you, Charles, and thank you to South Florida Hospital News. My name is Ben Merza. We are the law firm of Healthcare Law Partners. We primarily take care of things in the healthcare space, whether it be physician employment agreement, medical staff issues, leases of medical office buildings, things of that nature. And today's session is really intended for strategy officers, in-house general counsels, as well as administrators. And this is a seminar, so it's really for informational purposes, not intended to be legal advice for your particular situation. And with that said, this seminar is being recorded. So if you have something that's not of like that's very specific, I ask that you ask us offline directly. But you're always but it's always great to have general questions.
Don't forget to get her pill.
Hi Charles. Okay. Yeah. So then
can you see my shared screen? Can you see my shared screen right now or no?
Yeah, it's on market forces right now. So
okay,
if you can just go back one.
Yeah, let me go back one. Here we
So
go.
anyway, a little bit about our team. My name is Ben Merza. I have actually been practicing for almost 20 years. It'll be 20 years next month. And I've been inside large systems and small systems, meaning healthcare systems. And I've actually worked with a whole assortment of different healthcare contracting vendors. I've done a lot of leases, a lot of construction work, contracting related to the healthcare sector. I'm also formerly a certified public accountant, formerly certified in healthcare compliance. I have a master's of public health and administration and so forth. So those are some of my credentials. And today joining me is Ed Meyer and Cuomo Merza. Ed is my go-to guy for any time I need something. I need to figure out something as it relates to healthcare, and he is like by far one of the best brainstorming buddies you can have in the business. And Cuomo is actually my niece, and she is our young associate. Although she's been out for a few years, but she is another dynamite employment law attorney. So anyway, with that, Ed, you want to go ahead and introduce yourself with a little bit more detail?
Yeah. So I'm Ed Meyer. I'm been practicing, coming to my 30th year in healthcare law, and representing as a whole slew of healthcare providers, be it large health systems to small rural hospitals to large physician groups to individual physician organizations or individual physicians or individual licensees, even health plans that I've represented in my career. Always on the business side. I'm a business healthcare attorney and regulatory compliance attorney. Most recently, I was with Mednex there in Sunrise, Florida, in their Florida office, dealing with anesthesiology and with neonatology providers. But I'm very glad to give this talk, and also glad that Cuomo Merza is also joining us.
Good afternoon, and thank you for joining us today. My name is Cuomo Merza, and as Ben mentioned, I am his niece. We've known each other for quite a while. Prior to joining Healthcare Law Partners, I was an attorney with Legal Aid Service of Broward County, where I represented foster care children in Broward and advocated for their medical and legal rights in state court. And prior to attending law school, I actually worked with Alonzo Mourning Charities and a couple of congressional campaigns. And along the way, I saw how healthcare law and the healthcare industry could use some legal help. So that's how I started up at Healthcare Law Partners.
Thank you. I don't want to remind everyone that this presentation is not intended to be a legal advice. It's for general information, educational purposes only. Again, this seminar is open, it's live, and it's being recorded to be used in an open platform for online services. So know that this is being recorded also. So Ben was to chat a little about market forces that sort of focus on this presentation.
Yeah, so as the market forces, there's a big overall driving market force that's pushing a lot of the changes that are coming about. As we move towards more and more, we're just literally inching towards a national level healthcare provider system. That doesn't mean that the insurance companies go away. That doesn't mean Medicare goes away. I think it all kind of comes together, and they all continue to work in the same parallel universe. But with that said, what's happening is that the continued alignment of one organization with the next, meaning the insurance folks, the actual healthcare provider, the testing, the labs. Then you look at providers and for patient services, whether it's the outside clinics or specialized clinics or the hospitals or the ALFs or the nursing homes. It's all like a continuum of care, right? So that continuum of care is continuing to be a pushing force behind some of these changes that are coming about. The 2021 changes that we're going to be talking about today all go towards that. They're about sharing of risk. They're about sharing of healthcare marketing. The healthcare market needed more clarity as to what was appropriate and proper in the sector. So as a part of that, the most recent changes have brought about a lot more clarity, and Ed will talk about that with some pretty nice detail. Today we're going to be talking about primarily how it relates to physicians and healthcare providers. And in our next seminar, we're going to be talking about the new safe harbors that are coming out, also related to the same issues. So there's a lot of pull in the healthcare market space that's bringing about this change. Ed?
Well, thank you, Ben. So what I'm going to talk about for the next little while are the how to keep out of trouble, basically, for 2021, the new laws that affect physician contracting. Effectively, the new Stark Law regulations that were issued at the beginning of December that go into effect later this month, as well as the highlights from the 2021 Physician Fee Schedule. Both of those areas are interesting because what they do is they provide more clarity in planning for the long term, especially in the Stark Law area where there's been many questions and on how certain items are defined and how things work, and also giving some more flexibility in these new regulations for physician and hospital arrangements. Also, I'm going to mention the ACA, give you a little update on the ACA, and then talk, Cuomo and I will actually address the issue of some Florida employment law changes. And then we're going to have some Q&A at the end. But again, the Stark Law, we're going to also have in 2 weeks, we're going to have another seminar here on the Stark Law on more detail, more of a deeper dive on this. But the purpose of this discussion is to focus on the physician contracting issues in this new Stark Law regulations that came out that go into effect later this month. And one of the key things that happen in the Stark Law is clarification of certain definitions. Now, going back to the big picture piece, under the Stark Law, as you all know, is that physicians that have a financial relationship with a entity, usually that's a hospital or some other provider, they cannot refer designated health services, one of 10 types of services, to that entity, and that entity can't bill for those designated health services. In fact, those will be a false billing under the False Claims Act, if that are reimbursable under Medicare, unless that financial arrangement, be it a compensation arrangement, a purchase agreement, a lease agreement, or even employment agreement, unless those fall within specific exceptions for how those arrangements must be structured. Now, many of those exceptions, be the exception for personal service, for leases, equipment leases, office space leases, for assets, for employment, they have common themes. And what these new regulations do, they provide more clarity on these common themes, especially in the area of fair market value. Fair market value issues run throughout these exceptions as requirements. Also, that arrangement must be commercially reasonable. That also runs throughout the Stark Law. And finally, another common theme throughout Stark Law is that these compensation arrangements cannot vary based upon volume of or value of the referrals by the physicians or the business generated by the physician. So they provide guidance. These regulations provide guidance on how those definitions operate. The most significant one is the one of fair market value. And I've given you the fair market value definition right on top that came in the new regulations, which is very similar to what was there before, but they added some significant clarification. And that's real important to understand, especially in the area of rental equipment and office space leases. And they also provide a definition for what's this meaning of general market value. So what happened? So the fair market value they defined in these new regulations says the value in an arm's length transaction consistent with the general market value of the subject transaction. And they clarified for rental equipment, what are they talking about rental? They're talking about rental equipment, the value of a rental for general commercial purposes without taking into account the intended use. So you cannot take into account the intended use of the rental. And again, general commercial purposes, as if you're renting it to someone else, not just a referring physician. And that's the fair market value of the rental and how they evaluate that. Similarly, for office spaces. For office space leases, it's a rental for general commercial purposes, not taking into account the intended use and without adjustment to reflect the additional value attributed to the proximity or convenience to the lessor, where the lessor is a referral source. So we're talking about medical office buildings in this context. Space leases, fair market value being you can't take into account, the fact that it's close to the hospital that they're going to get referrals from. They just clarified that in these new regulations.
If I could add, go ahead. I'm sorry.
No, go on.
Yeah, so if you can just go back for just 1 second. So there's a few practice pointers that you actually need to keep in mind when it comes to actually rental equipment or even purchasing of equipment. You got to be careful about that. There's no free product attached to that equipment. If there's free product or if there's lopsided sort of an attribution of value, you got to be careful of that, because you got to get them to fairly value the equipment and the disposables that are coming along with that equipment. So, like, for example, there've been regulatory cases involving a kickback scheme having to do with like the free P cups. Some of you guys may remember that. If you take a look at like the Halifax case, in the Halifax case, there was actually free space being given to a particular physicians group. So you got to be careful of like, there's no free space being given away to a physician group. Then you also have things like, some providers were actually being given free usage of staff without a chargeback. You also have to look at like free internet use if there's a office space lease. Free garbage disposal that that they might be getting away with, or medical waste disposal. There's even things having to do with like, how some hospitals will have a valet service. If your medical office building is actually attached to a hospital, and there's a free valet service being given, you have to also take that into account when you're looking at a medical office building lease, because now you're giving something of value, like a valet service, to all the patrons that are going to be visiting that. So in your FMV, you just got to make sure that these little knick-knack items don't get away from you, because you gotta specify exactly what is being being provided to the tenant.
You got to call that out. So in other words, what Ben's really saying is you can add those those items. They have to be spelled out in the lease, and they have to be valued. So even though there's not a specific per use charge of the valet, that valet service is in the lease, and the valuation consultant who's looking at the rental charge is taking into account the fact that there's also these other services that are going along with this space lease. Again, like in a value and arm's length transaction consistent with general market value. So if you look at the market and adding all those things together for a fair market value. So they also gave a definition for market value. Let me see. I got it.
Ed, can I jump in for a quick question?
Sure.
How does that relate to any exceptions under emergency rules that are still existing, carrying over from the COVID situation? Are some of these suspended or at least modified for that?
Yeah, there's certain waivers for in emergency arrangements for COVID dealing with fair market value. So they did provide certain arrangements. Let's say you're bringing a physician in to a hospital, and you, because of the emergency, you really can't get a value in there, and it's going to end up paying the physician over a fair market value. There's a current waiver that's in place only during the declared emergency for COVID. And again, the purpose of that arrangement is to address the COVID pandemic. The extensions that we'll talk about later that extend these waivers beyond the declared pandemic do not address do not extend those types of waivers on fair market value. A good question, Charles.
Right, thanks.
Yeah. So on general market value, they also define it as a component of fair market value. So what do they mean by general market value? Well, they talk about it in the context of assets and compensation arrangements, asset acquisitions, compensation arrangements, and rental agreements. So for asset acquisitions, and the common theme to each one of these is the value at the time of the transaction. So look at this here. You got assets. The price that an asset would bring on the date of the acquisition of the asset as a result of the bona fide bargaining between well-informed persons that are not otherwise in a position to generate business. Similarly, in comp arrangements, be it compensation for services with the physician, it's paid at the time the parties entered into compensation paid at or payable at the time that they entered into the arrangement as a result of bona fide bargaining between well-informed persons not otherwise in a position to refer business. And similarly, for equipment leases and space leases, the price of the rental property that would bring at the time the parties entered into the rental arrangement as a result of bona fide bargaining between the well-informed persons and lessees without their position to generate business for each other. So again, there's really two components here. It's the time that the contract's starting. That's when the fair market value is evaluated. So I've often seen in contract discussions is a contract's gone on for a couple of years and they're saying, well, it's no longer fair market value. The market has changed, so the value is different. Well, for purposes of Stark evaluation on the fair market value element, was it fair market value at the beginning of the contract? And again, fair market value without regard to the fact that there's referral sources that are in play. Not fair market value during the course, but fair market value during the course does take place with regard to another element in Stark, which is the commercially reasonable element. So Stark has this issue that arrangements need to be commercially reasonable, but they never really defined it until now. What does commercially reasonable mean? So they defined it here in these regulations. And what they basically said is commercially reasonable if the arrangement furthers a legitimate business purpose of the parties, is sensible considering the characteristics of the parties, including their size, scope, and specialty. But they called out very specifically, and this was a question about commercial reasonableness that many had before they put this regulation is, well, what if you don't make a profit? Is it commercially reasonable not to make a profit? Well, they said there's sometimes it may be commercially reasonable, even if it does not result in a profit for one or more of the parties. So let's take, for example, you're dealing with hospitals that are tax exempt, and they're focused on meeting a community need of underserved population, and they're not going to make a profit, treating the underserved, that still would be commercially reasonable. If that they're not making a profit. The fact that they didn't make a profit does not negate the commercial reasonableness of the transaction. So that's an important, very, very important factor to keep in mind. Then also what they did in the Stark law is this issue of volume or value of referrals. The compensation in many of these, in all of these elements, the compensation to the doctor can't vary based upon volume or value of the referrals or business generated by the physician for designated health services. But so especially in the area of unit-based compensation, where you're paid per unit, per activity, let's say per read, they gave some pretty good clarifications here. So it's not considered to have varied based on volume or value if it's fair market value for the services actually provided, and does not vary during the course of the comp arrangement in any manner that takes into account referrals. So that's a good guideline on making sure you're outside of the problem area of volume or value. That as long as it's still fair market value and it's not varying, the comp's not varying during the course in a manner that takes into account referrals. So it can vary, but not with regard to referrals, taking that into account as how the variance. Also, physician comps that takes into account volume or value referrals only if the compensation includes physician referrals as a variable, resulting in the increase or decrease in the physician comp that positively correlates with the number or value of a referral. So you cannot have a correlation between the referrals. So you're setting compensation if you're correlating referrals by that physician to the price, then that's a problem under the volume or value under the Stark law. Any questions? Now, let's talk about duration of contracts. Now, this is something that, had been a little bit of a debate under Stark, and where some folks, Stark basically says contracts have to be a term for at least 1 year. So what happens then if you have to terminate the contract during the year? Some had argued that, well, you could terminate the contract during the year, but then you could enter a brand new contract with the same physician for another year during that course. So you kind of lay over year to year to year. So you think like first month, 3 months, then you terminate it, then you have a new contract, same service, change the comp, but then that's a year length. They were very clear now. You can't do that. You really can't do that. So basically what they're saying is that for space leases, equipment leases, and for compensation arrangements for administrative services, such as call coverage or other sort of services by the physician, that if you terminate that contract within the first year, whether or not you're terminating it for cause or without cause, you cannot enter into the same or substantially the same arrangement during that initial year. So you got to wait till the end of the year. Now, earlier I was talking about this with Ben, and Ben asked me, so what happens if this doctor, you start with a contract, let's say it's $100 an hour, he's going to do it. And then, a few months in the line, the doctor says, hey, I got another offer to do the same for someone else for $120 an hour. But I'll if you match that, I'll continue doing this, and I won't operate my, 30-day, 90-day termination notice to get out of this. Really, you can't change the comp if it's during that first year. You got to basically tell under this rule, you got to tell the doctor, if this contract's being terminated, I can't enter into the same arrangement with you for until the end of that first year expires. So what's the solution? Well, you can't do it. Or you say, well, you got to do some additional services for that additional compensation. So you're changing it. It's not the same set of services. Similarly, let's say you had one doctor and it's $100 an hour. Now you're going to need to add another doctor. Well, that's the new set of services, now from one doctor to two doctors. So you could change the comp during that 1 year to address the fact now there's two doctors and creating some efficiency. But you need to call that out in the recitals to be really clear on why comp changed and that it's not the same services, and be clear that you weren't doing the same or substantially similar, same or substantially the same services during that first year. Similarly, there's this fair market value compensation exception to Stark. And then you can't use that to have the same arrangement, one or more of the same arrangements for the same services during that course of the year. What's interesting too is Stark really provided great flexibility, these new laws. And that is this new limited remuneration to a physician exception. And that is dealing with the fact that you all have arrangements with doctors. Sometimes you need to call a doctor in and to do some service or some items that they're selling them or something, and it's small dollar amount. And you didn't paper it. You didn't get some signed beforehand. And so say, for example, the doctor's coming in and needs to assist in a peer review, especially, but yet he wants to be paid for it because he's not really on the general panel, and you pay him a little bit under $5,000, but you didn't paper it. Okay, well, as long as it was the government realized and say, look, $5,000 is really, if it's during 1 year, 1 calendar year, if it's services by the doctor or items by the doctor to the hospital, it was the total is less than $5,000 during that calendar year, and the compensation really isn't taking into account the fact that there's a referral relationship or the volume of referrals, and it's really fair market value for that charge for the service he's going to do. Then it's okay that you're still within the Stark. That's a specific exception, and that really removes a lot of these little things that might occur that people say, oh my gosh, it's a small arrangement, we entered into it, and now we got a Stark problem. Well, you had one up till the 19th of January, because that exception doesn't start till the 19th of January. But once with the new exception, it really clears a lot of these small type of matters, as long as the aggregate comp is under $5,000 and fair market value doesn't relate to fair volume or value. And again, when dealing with leases, it can't be based on percentage of revenues or per unit service charge, reflecting lesser to lesser referrals. I do want to mention, in a major part of these regulations, and we're going to get into this in our next seminar, so I really encourage you to listen to the next seminar in 2 weeks, and that is this value-based arrangements exceptions that they added in on this whole issue of encouraging working together between hospitals, physicians, and others on the continuum of care to patients. And so these arrangements were basically hospitals, physicians, and other providers get together and create an enterprise. The enterprise basically goes to a payer and says, look, we're going to take financial risk from you in exchange for a fee, and we'll take full risk or in one way. But in doing this arrangement, to be able, since you're taking risks, you got to tell the doctors they have to make referrals within this enterprise, but for this target population that you're going to be treating. So there is specific exceptions that were added for value-based arrangements, either a full risk arrangement, you're taking all risk for the payer, or there is an arrangement where the physician is taking meaningful downside risk. That is risk that's a set aside effectively of at least 10%. And again, to take care of a target population, and that physician is required to make referrals for that targeted population that's under this arrangement within the hospital. And there's another exception for arrangements that meet exceptions for value-based arrangements. So those are out there, and they're new, and they're providing some good guidelines for hospitals and physicians, joint arrangements to assist in the continuum of care on a value-based basis. So those are really the big ticket items for the Stark law changes. I want to turn now to the CMS Physician Fee Schedule that came out at the beginning of December, because there are some interesting pieces in there that are helpful to physicians, or physicians just need to know about. The first one is that when it decreases the compensation factor down to $32.41. It was a little bit higher than that before, starting for calendar year 2021. And also what it did is it finalized the addition of the list of services to the Medicare telehealth list for a category 1 basis. And that basically means that for calendar year 2021, they added these telehealth list to the Medicare telehealth list on a category 1 basis for services such as a group therapy, psychological, neurological testing, home visits for an established patient, cognitive assessment, and care planning and services, etc. So they provided these on there, and they also added through the end of 21 certain of these telehealth codes that they had put in place during the pandemic. Now, this is really important because we expect, because now the vaccine's out, that at some time this year, the pandemic very well may be declared no longer a national emergency. Many of these exceptions that we just spoke about with Charles a moment ago, many of these exceptions were in there just for the purpose of while the pandemic's in place. So once that national declared emergency is no longer in place, they no longer have authority to provide these exceptions unless they issued a new regulation. So what they did in this physician fee schedule is for certain things, they extended the this list for telehealth, for certain telehealth things through the end of calendar year 2021. They also clarified that telehealth rules do not apply when the beneficiary and the practitioner are in the same location, but in different rooms. So for example, if the patient comes into the office is in one room, but the physician, to keep safer, is in another room, but is using television, telehealth, that's not telehealth for purposes of these rules. So there's these telehealth exceptions really don't apply. The CMS rules also were issued regarding the professional scope of practice, recognizing basically that there's a shortage of physicians, more people need care. And so they were clarified certain items dealing with non-physician practitioners. So for example, they make a permanent their policy to allow nurse practitioners, clinical nurses, providers, physician assistants, and others to supervise the performance of diagnostic tests, as long as that's within their scope of practice and within the state law. Similarly, they add CRNAs to that list of who may supervise diagnostic tests, perform diagnostic test supervision. But as long as the CRNAs still have that relationship with a supervising or collaborating physician. Also, they clarified that pharmacists may provide services incident to the physician services. So they may provide services incident to and be billed as incident to services as long as there's appropriate supervision of the billing physician or billing nurse, not non-physician practitioner. But as long as being careful that pharmacy services is not also billed under Part D, so there's no double payment. So that was an interesting addition that they had, again, with collaborations with the physicians and pharmacists together. In addition, they dealt with Medicare medical record documentation issues in these new rules. So they clarified that physicians and non-physician providers, including therapists, can review and verify documentation entered into the medical record by members of the medical team for their own services that are paid under the physician fee schedule. So again, that allows more of a leeway when you're dealing with a team approach in how medical records are being entered into, like say electronically, then reviewed and verified. So that's a positive development. And they clarified that therapy students and students of other disciplines that are working under a physician practitioner basically furnishes their bills directly for their services, and they may document in the record if the documentation is reviewed and verified by the billing physician. So those are some of the changes. I recommend that the easiest thing is, if you're interested in these things, is pull up CMS Physician Fee Schedule for 2021. There is a great summary on the CMS website that goes through the changes and summarizes the changes that are in the physician fee schedule. In fact, calling out these extensions where they're extending some of these temporary waivers It's beyond the end of the declared pandemic, oftentimes to the end of the calendar year in which the pandemic is declared. But it's a great site. It was issued on, I think, December 1st or December 2nd by CMS. So if you get on their website, get on their public their news items, and go back to December 1st, December 2nd, you can find that pretty easily on the cms.gov website. Now, Affordable Care Act. You may recall that earlier this year, a new Justice Supreme Court got on. There was a lot of debate. You put this new Supreme Court justice, she's going to throw out the Affordable Care Act. So I just thought I'd give you an update of where it is. Well, the court heard the case, but they have not yet decided on it. So, and what was that case? It was the case is whether it was Texas v. U.S. Secretary Azar. And that is whether or not the individual mandate is unconstitutional. And if it's unconstitutional, is it unseverable? Could it be, if that individual mandate is unconstitutional and you throw it out, does that mean the entire Affordable Care Act gets thrown out? That was really what the court's looking at. But keeping in mind that in most states, the individual mandate has a $0 penalty if one's not complying with it. So I think that's probably a big issue the court was weighing on whether or not to throw out the ACA. And so I can't really predict what's going to happen, but that's where it is right now. So it's a wait and see. Sometime probably the summer, they'll see what the court says, whether they'll say one individual mandate is constitutional, or they say it's unconstitutional, but it's still not severable. It's still severable. So if it's unconstitutional, the whole thing still stands. So, or they say, well, it's unconstitutional and you can't get rid of it, so the whole thing's gone. So it's still up in the air. Bottom line, wait and see. But what did change though is the maximum out-of-pocket limit has increased to $8,550 under the ACCA. But the rest of it currently remains in effect, so it's still in effect. Keep that in mind. And finally, we're going to chat a little bit about Florida laws. Colby, you want to mention what the EVerify?
Sure. Thank you, Ed. So as of January 1st of this year, the Florida law now requires all employers who are public employers or bid for public contracts to e-verify their employee identities. Essentially what that is it requires the employer to cross-reference or record the Social Security number and the I-9 forms for employees, and then cross-reference those with the Department of Homeland Security's database, which essentially works to make sure that the Social Security number or the IRS records that the employer has are not being used elsewhere by an alternative employee. This is primarily a result of, over the last 10 years, I'm sure you've seen headlines in news where hundreds of illegal immigrants are arrested while at work and being employed by private and public employers. What initiated that was identity theft concerns that were risen, which led to an investigation. And what happened was that multiple people, meaning sometimes up to hundreds of people, were using one person's Social Security number and IRS information for the employee, for their employee records with their employer. That obviously triggered a investigation by the Department of Homeland Security, as well as other agencies like the Department of State, and led to these eventual arrests. This helps the employer make sure that they're appropriately employing their associates. And really it's one more thing. I like to think of it as one more thing that you just have to make sure you have on record for each and every single employee. This is in addition to the level 2 background checks or the level 1 background checks. In the healthcare realm, level 2 background checks are the most important, primarily because the Florida's legislation requires that anyone with deemed to have a position of high responsibility or trust is required to have a level 2 background check. What that means is that somebody working directly with children, the elderly, the disabled, must have had a background check where their fingerprints are taken and then cross-referenced with the FBI database, and which then provides a feedback or a criminal history background on a national level. These are both things that every employer should make sure to have, not only for their physicians and healthcare providers, but also anyone else that they may employ.
Yeah, what's interesting is keep in mind that I might recall that back during the Clinton administration on the requirement for I-9s, that was a key thing that where the government was reviewing for employer compliance. They could do an audit and have you done your I-9 and gone after employers for non-compliance. Similarly, now there's a state law, the governors, the administration can go after employers for not using this EVerify for all of their employees. So again, that could be an enforcement tool that could be used to sanction employers. So important.
Exactly, and the consequences can be very severe. And building on that, I mean, the legislation now states that it could lend to suspension or termination of your business license. So the consequences are very, very severe for employers. So it's
Is there a charge for the EVerify system by the government?
It depends on which service you use. And you can register with the Department of Homeland Security, and there could be charges associated with that.
Okay.
Yeah. So in addition to EVerify, keep in mind that there's a new minimum wage in Florida.
Right, and so as of January 1st this year, the minimum wage increased to $8.65 an hour. By September 30th of this year, it's going to be $10 an hour. And then there's going to be an incremental dollar increase every year from there on out until September 30th, 2026, at which point it should reach a minimum wage of $15 per hour. And that's for your hourly and wage workers, employees.
So keep that in mind. Keep that in mind.
Pretty significant.
So thank you for bringing that up, Cuomo.
Thank you.
Yeah. So again, thank you all for this. I hope you found this interesting. And again, what they were doing, Stark laws are clarifying a lot of things. Looking forward to providing a little more clarification and more guidance, providing that exception for $5,000 for small arrangements. And then in the physician fee schedule, there again, I really suggest you pull that up, that press release up to see what they did, because that's really going to help you have planning for 2021.
And if you're tussling with any sort of a specific situation, you may want to reach out to us, me, Ed, Cuomo, and we're happy to walk through that scenario with you. Also, just a reminder, our next seminar is going to be on January 19th, and that's going to have in it the 2021 safe harbors, the new safe harbors that are going to be in effect as of January 9th. Right? They go into effect January 19th, right, Ed?
Yes.
As well. Yeah.
January 19th. Yes.
Yeah. So, any questions?
Well, thank you
Okay,
again.
we will be posting both in my newsletter, on my website, and on Ben's website, the recording of this for you to review if you'd like to, share with your colleagues and peers. And I know you're getting invitations to be able to come to the seminar. If you would, please share it with a friend. If you think that somebody could benefit from something that's going on, wants to listen to it, and possibly ask some questions, it's always better to do it live than it would be to just listen to somebody speak for about an hour without having any interaction. So if you can take an hour out of your day, you don't have to show us your face. You can eat lunch at the same time. And if you have a question, just come on in and ask the question. So again, I want to thank you for coming in to this joint effort to hopefully educate and keep you up to date on what's going on in the healthcare market from a legal perspective. Any last words, Cuomo, Ed, Ben?
No, but again, thank you. It's great, Charles. You know, really, this is a great public service that you're providing by giving this out for folks. So again, I just want to thank Charles for arranging all these things. So
Okay.
a lot of changes, yeah.
Thank you, Charles.
All right. Well, and if nothing else, I want to again thank everybody for coming in this afternoon. And you saw Ben's information to reach out to him. If you didn't catch it in time, you do have my email. I'll be glad to send it to you. And look forward to receiving a copy of the video in your email in the next couple of days. Thank you again for joining us.
Thanks, everyone.